which is a new petition submitted by Mr. Landrick Highland dated July 4th, 2016 against Kenneth Goodnow as a companion to petition number 2015-03. Yes.
Madam Chair, sorry, do you want to take up that matter first?
Yes, please.
Okay. First of all, for the record, Special Deputy Corporation Counsel Gary Murai. The members, if you look at the new petition that has been lodged against Board Member Goodenow, I suggest that you refer to rules 4.2 and 4.5 of the Rules of Practice and Procedure of the Board of Ethics. And note that Rule 4.2 requires that that a request for an informal advisory opinion by a third party require, among other things, that the writing should be legible and on paper 8.5 inches by 11.5 inches in size, that it be submitted in duplicate, and that it be signed by the third party or his representative. And if you look at Rule 4.5, Rule 4.5, rejection of request, provides that in paragraph C, in no case shall the board entertain a request that is not in writing and not signed by the person making the request or his representative. Excuse me. Now, there may be other issues with regard to this. It's been styled as a petition, but before we can even get to the substance of that so-called petition, in other words, determining whether it even alleges a violation of the Code of Ethics, I urge you to consider Rule 4.2 and 4.5 and first determine whether the matter is even properly before the board.
Yes, please, Mr. Adams.
One of the questions I had coming into this was whether or not this was actually a 1.5, Rule 1.5 affidavit, as opposed to a 4.2 petition.
Well, it's styled as a petition.
I understand, but how we take it up matters. Yeah, I was just going to say, if I can ask, is the version that we have in front of us without the signatures, is that what we received? We didn't receive one that had signatures?
We did a couple days later.
Okay,
Email.
so we do have one that does have signatures.
One thing, yeah, in fact, I wasn't aware that there was a signed version that was received, but it did not make it in time to be placed on the agenda pursuant to Chapter 92, the Sunshine Law. The agenda must be posted 6 working days prior to or 6 days prior to the hearing.
Mr. Goodnow?
Well, of course, if it's a petition, I'm going to recuse myself. But I'd like to say, look, I mean, the heart of the matter is that Mr. Highland's claiming that I can't be fair. And whether we take it as a petition, and I appreciate the procedural need to dismiss it if it's a petition, I don't have a problem with that. But I mean, my whole, it's only extending the issue further and further. I'd prefer that, hey, if you want to treat it as a conflict of interest, I have no problem with that. I'm not going to give my opinion because it involves me. I mean, I'd like to at one point kind of make a statement about it. But at this point, whether you take it as a petition or something else, I have no objection to that. And maybe Mr. Highland would be agreeable to just including it as part of the discussion of Billy Canoy's matter and just saying, hey, it's like a communication. We're going to talk about it. But because it's not signed at this point, it's not necessarily a petition. I'm open to however you all want to handle it. I just wanted to put that on the record.
Madam Chair, if I may.
Go ahead.
If Board Member Adams asks whether this could be construed as a affidavit of disqualification pursuant to Rule 1.5, the bottom line is it's not that either, because an affidavit requires a signature under oath, and of course the respondent in this case, Board Member Goodnow, would have to have an opportunity to respond.
That's why I was saying it depends on, it matters how you style it, absolutely.
Well, but certainly we cannot tell. Well, it's not the board's job to give advice to litigants on how they want to conduct their case. Certainly, we can presume that Mr. Highland has the rules or access to the rules, and of course he's bound to follow them, like all parties are.
Okay, so basically what we have is we have a quote unquote petition, meaning it was not filled out properly when it was received in time, and then but it had to be put on the agenda because it was received. And so it's up to us to decide whether we would like to hear it today or not. We do have a signed petition that came in 2 working days or something. Okay, prior to this meeting, however, not within the deadline. So I would suggest maybe our first item would be to see whether we would like to hear this petition at this point or not. Mr. Goodnow first, and then Mr. Adams.
Thank you. Well, I'd like to ask Mr. Highland. Well, let me put it this way. I'll get to what was said or not said, but basically my position has always been that we need to wait until the trial is done, if possible, and have the hearing. It's always been my intention that we have a hearing. In your testimony at the last hearing, which I agreed with, it's not going to take numerous days. This could happen very quickly. I agree with what you said. I'm not sure if it matters to you. I mean, why not have it in November when the trial is over? I'd be interested in your opinion on that. But I'd also like to say, as far as the comments, look, I always try never to comment about board business. I feel that's appropriate. Now, I may not always succeed in that. I will admit on occasions, I've had friends come up to me and say, "Oh, you postponed the postponement again, ha ha ha," right? And I may respond to them. I would never say I would postpone that I made a motion and, that we postpone till whatever.
Madam Chair, point of order.
Oh, well,
Yes.
I'm asking
point-
Mr.
No, but
Highland.
we don't
Point-
even have a motion yet.
Point of
so-
order.
Well, I'm asking a question of Mr. Highland about his petition.
But we haven't even determined yet if we're going to hear the petition, so I think we should
Well, my
do
question
one
is
thing
going
at
to
a
be, will
time.
he withdraw it based on my representation?
Point of order.
Mr. Adams?
We're engaging in discussion on something that we haven't even taken up.
Well-
That's just, we need to do this the right way.
Well, there's nothing wrong with me asking him if he will withdraw his petition.
At point
That's
of
what I'm
order,
trying to
yes,
do.
there is. We need to have, just because the thing's on the agenda, it's been agendized and we brought it up, we have yet to actually bring the item forward. And so for us to actually have a conversation on this, we have to have some type of motion where we've accepted this petition.
I've always said you need a motion to have discussion. I've been told with this board that's not true. We take testimony or ask questions of the petitioner first, and then we make the motion. So I'm sorry if I didn't follow what I
having-
thought was our procedure.
We're having discussion. So if the idea is to then go into, if what you want to do is initially allow the individual to provide a testimony and then ask the questions based on the testimony, that's my understanding of the procedure. But my understanding is that we haven't yet even determined that we're taking this up as a petition.
I would suggest that the first order of business be the board's determination whether to accept the petition.
All right.
Then the board may have discussion on it. Normally, a petition is regarded filed once the board accepts it.
All right, so in that case, would we need a motion to do that?
Normally it's kind of a pro forma thing,
Okay.
in other words, going over whether it meets all the criteria. But in this case, well, it appears that there may be some deficiencies, so therefore I'd recommend that the board it should probably be a motion, by motion.
So I will move that we don't accept this petition in its current form.
And I would second that motion.
It's not that we would never consider this. It's that, to me, we have the ability under 4.5 to accept it. My concern is the Sunshine Law. This did not meet the Sunshine Law requirement. And as a result, it's not just the ethics code that we are up against here, it's Sunshine Law requirements. And so that becomes an issue for me. Does it mean that we would never consider it? No, we actually have the version signed that it seems to me would be provided then at the chair's discretion, obviously, to be considered at the next meeting, because obviously that's well in time for Sunshine Law requirements. But I probably would be predisposed, had that not been the case, as being a hypothetical conversation and all, to accept it because we have that authority under 4.5. But when we're up against Sunshine Law, we do the same thing for everybody else. That's just the way it is.
And the
Robinson?
other thing for me, in addition to the Sunshine Law, is the fact that it's based upon hearsay by an anonymous source. I mean, that's just so out of anything. I just couldn't believe it when I read it, that it was be based upon hearsay by an anonymous source.
For me, it's a procedural concern. We have procedures, and those procedures are very, very clearly spelled out in the Code of Ethics as to what constitutes a petition, and it includes being signed and being in the proper form, which this particular petition was not. So I would be voting also in favor of dismissing this petition.
I apologize. I will say Mr. Adams is correct. I was not thinking of the Sunshine Law. I think that makes a difference, and maybe I shouldn't have brought in discussion via my question now that you mentioned the Sunshine Law. I appreciate that. I guess we have to be safe. As much as I would like to end matters, I think Mr. Adams is right.
So the motion is to dismiss the petition and, not dismiss, I'm sorry.
Proper motion,
Is-
and to Commissioner Adams, I mean, Board Member Adams, I forgot exactly what you said, but it would be to not accept.
That's right.
Not
And
accept.
that's why I wasn't clear. So the motion is to not accept, I'm sorry, not accept the petition as it was submitted. All in favor to not accept the petition as it was submitted, say aye.
Aye.
Aye. Any opposed? Oh, and one abstention. So 4 in favor and 1 abstention.
The motion carries. Madam Chair, just for the board, for the staff's direction, now I've not seen the signed petition, but I presume that that matter will be placed on the next meeting's agenda. Not to say that it's going to be accepted, but at the next meeting, the one that has been received by mail will be placed on, and the board will then review it again to determine whether it meets all the criteria of the board's administrative rules. Is that a correct?
That's my understanding, yeah. Now, does that then eliminate the entire petition number 2015-03, or do we still discuss that?
It's Madam Chair, that matter is on the agenda for, I believe, for further review. I'm sorry, continued review. And I presume that what that means is review of the current status, which is, I believe the status right now is that it has been deferred.
I believe Mr. Adams. Right. Mr. Adams had a motion that we put it back into consideration. We had a 2-2 vote, and it was automatically deferred to the next meeting, which is now. So, I mean, I don't know if you want to make a new motion, but there is, I guess we do need a new motion because the previous motion ended in a 2-2 vote.
Madam Chair, can I ask permission to ask Mr. Marai a question?
Not at this point in time. But I am noting that you have a question.
Well, I'd appreciate it because I would like to make a verbal motion for Mr. Goodenow to recuse himself whenever that's appropriate. Thank you.
Thank you.
He can't make the motion, but maybe I should raise it.
Actually, Mr. Highland did not make a motion. He made a request.
Request.
Yeah.
Right. Well,
Okay, so I think at this point in time, based on what I understand,
would put forward asking whether I have a conflict or not, and ask for the board to determine whether I have a conflict, which would be Mr. Highland's allegation. However, that matter, is that on the agenda? Are there sunshine law issues? With that, I don't think so. But do we want to, I mean, I'd prefer to get this done today.
Whether, Board Member Goodenow, whether you have a conflict or not, I suppose the first person that would know that would be yourself.
Right.
Because you can either disclose a conflict or a potential conflict and voluntarily recuse yourself, or if there has been, as Board Member Adams correctly points out, if there has been an affidavit alleging that you may have somehow have a bias, and after a proper hearing, the other board members concur, then the board, your fellow board members would determine whether you do or do not have a conflict that would require recusal.
Okay. Well,
to me, if we're talking about petition number 2015-03, I don't see the conflict in interest in that particular petition. However, if you do have a conflict, it would be nice to know.
even if I had said those things, there's no legal basis for a conflict.
Well,
So I don't know what to say. I mean, besides, I don't believe I have I can be fair. I've always supported having a hearing. I mean, besides saying that, so I guess I won't ask for a determination or declare a conflict. I won't declare a conflict.
well, if there is no conflict, then I would suggest that the board proceed.
Okay.
Given that we have 2015-03 agendized as unfinished business, which for the purposes of our audience in Kohala in particular, the petitioner, means that, as I understand it, the testimony's already been provided by the petitioner when it was new business. We're now into unfinished business. And I would, again, move to end the deferral of the petition and bring the petition back for consideration.
I'm sorry to interrupt, Mr. Adams, but we've neglected to note that, for the record, that Mr. Singh, the respondent's counsel, is present, and perhaps we should invite him up to the table.
Yeah, Mr. Singh, could you please come up and introduce yourself and then let us know your opinion here?
Good afternoon. My name is Richard Singh, and I'm counsel for Mayor Kenoy.
Actually, I'm sorry, I interrupted while there was a motion pending without a second, so
And I'll second that motion.
And the motion is for continuance.
No, the motion is to end the deferral and bring the petition back into consideration.
And so you have a statement in regards to that. Thank you.
Thank you. Our position remains the same that it has been since the beginning in this case. We believe that the commission should, or the board should defer action until after the trial. As it stands currently, the trial is set for October 10th. It's relatively firm as these things get at this point. We expect it to take quite a while. We expect selecting a jury to be quite a task. And the more media coverage, the more outside discussion of this in this kind of form, it makes that process harder. And so that is one of our main concerns. My secondary concern is that my understanding is that the board had already decided to defer this, and we're talking about a reconsideration of this. Nothing substantially has changed since that previous decision was made. So that's my other concern is the case is proceeding as it is, and we have a set date in the relatively near future. This isn't some far away date that we're talking about. We're talking about October, and it's while the mayor is still in office, and that case will be decided shortly after that. So it's our position that the deferral is the right move here, and that's what we would ask.
Any further discussion?
In the,
Mayor,
yeah, in the essence of fairness, I'd like to give Mr. Highland the opportunity to comment.
Yes, Mr. Highland?
thank you, Mr. Adams. Oh, my. Okay. The mayor's term expires on, I believe, the 5th of December. So any trial, to postpone this until after the trial, and Mr. Singh has already said it'll be a lengthy trial, so it'll probably run into November. So the board has to wait until its November meeting to put it on its December calendar, but by then the mayor will no longer be employed by the county, and that means that you folks are not going to hear anything about this petition. It will just die when the mayor leaves office. Now, we've already heard there are changed first, sir, addressing Mr. Roberts. This is, I only did not include the name because I didn't know if you were going to deal with it at all, and I didn't see any point in getting that lady involved if nothing was going to come of it. I don't know the lady. I had never met the lady. I still have never met the lady. I've only talked to her on the phone, but she did confirm what she heard, and she confirmed that Mr. Goodenow was anonymous to her before she overheard him in the hall. So I just wanted to get that into your statement about it being anonymous and not under oath. But more importantly, the evidence is, as we heard from, I think, a much better judge of what's appropriate than Mr. Singh. We heard from the Attorney General himself, the head law enforcement officer for this state, that there is no problem with this ethics board determining a question under its jurisdiction and not waiting for the result of the criminal trial. Now, I challenge, I mean, I'm only 76, so I haven't been here that long, but I would challenge anybody to point out any other ethics commission complaint that was continued until after a criminal trial was held. That just doesn't happen. And the issue of poisoning the jury pool, there's an alternative. They can ask for it to be tried, Mr. Kanoy's case to be tried off island, if they think that our jury pool is not pure. I'm sure that they're going to be able to find 14 jurors who have not been prejudiced by whatever evidence this board hears about Mr. Kanoy. And your hearing should not take long. You have Mr. Kanoy's television testimony, and you have the county auditor's report, and that pretty much gives you all you need to make a determination today on whether or not Mr. Kanoy violated the code of ethics. And after a year, I'm just trying to get the matter heard. And I'm afraid if you continue it, it's not going to be heard because Mr. Kanoy will no longer be mayor. I would point out an historical fact also, which is years ago, the mayor was charged with third-degree assault. And his case, the witnesses in his case, the victims, were the people who were going to testify. And the mayor continued that case until after that person who was in the Army was sent back to Afghanistan, rotated back to Afghanistan, and there were no witnesses. Now, I'd hate to see Mr. Singh or the mayor simply continue this or have this continued past the time when the mayor is in office, when you know that as long as he is no longer in office, you're not even going to hear this case. Thank you.
Thank you, Mr. Hyden. Any further discussion?
My position's, I think, pretty well known. I made the motion. I think that it's appropriate for us to take this petition up.
I have a comment. If I could ask you, if we had a hearing in November, and this matter was resolved by this body in November, would that make any difference to you as opposed to having it resolved, say, in August? Does that make a difference, the time frame in and of itself?
Yes, sir. There's a maxim about that. Justice delayed is justice denied.
And Mr. Singh, if we were to have the hearing now, say, I mean, I don't want you to speculate, but if we had it after the trial, if we had our hearing after the trial, would you anticipate Mr. Kinoy to take the Fifth Amendment or not speak to us?
I'm sorry, I didn't understand that question.
Well, it's meant for Mr. Singh. I agree it was a little awkward. I'll rephrase it. Is there a difference if we have the trial now versus after, I mean, not the trial, the hearing now as opposed to in November? Does it make a difference?
The difference, I think, primarily is, as I described, that we are about to have a giant public trial airing these exact issues. And waiting until after the trial, in my humble opinion, is the smart move for this community.
As far as the Attorney General never said formally to us, there was a newspaper article which he was referred to as saying that there was no reason there shouldn't be a civil proceeding prior to a criminal proceeding, say like in an administrative driver's license revocation situation. I mean, granted, he was the head of the office investigating Mr. Kinoy when he said that, but I mean, we haven't received anything. He has not made any comment to us. Do you have any comment about that?
Well, I actually think it's quite similar to Mr. Hyland's other petition today, where there's an anonymous allegation. I think you have a situation where you have to look at exactly how you're going to move forward. And when you have a situation where this board is getting its information from a news article rather from some direct communication, I think that that's a bad practice. The same way accepting petitions that make anonymous allegations is a bad practice of hearing them. So that's my opinion.
And do you think the mayor might be more open to speaking candidly with the board after the trial as opposed to now?
He's not here, and I
Right, you
can't
can't
make
speak for
commitments
him.
on his behalf because I haven't discussed this with him. But it's my opinion at this point that the same considerations that are in place now prior to trial are not the same considerations that are in place subsequent to trial.
Can you say if the mayor supports hearing the petition while he's in office?
I'm the mayor's attorney, and I can tell you we support this board's decision to defer hearing it until after he gets a fair and full trial. That's coming in a couple of months.
Thank you.
I think one of the things that would help us also is I think that there's some misconception as to what the power of this board is and what kind of consequences would result in hearing or making a decision in regards to this petition. And so maybe if you could have corporate counsel just explaining to everybody so that we're clear what parameters we have to work under.
Madam Chair, the Board of Ethics, under its rules and under the Hawaii County Code, what this board does is issues informal advisory opinions either upon request of an employee or pursuant to a petition for a complaint against a county employee. If the board concludes that the employee's actions or intended actions may run afoul of the code of ethics, then what this board does is it issues initially an informal advisory opinion. If the county employee complies with the board's instructions, then that's where the matter will end. If the employee insists on continuing the behavior that led to the issuance of the informal advisory opinion, then this board may then take it to a formal hearing, and upon a finding in a formal hearing that the county employee still continues to violate the code of ethics, then the board may consider referring it to the county referring the matter to the county council. Now, this is not to say that that's all that can happen, because the county employee, depending on what the action was, may still be disciplined by a department head or by the county council, and by discipline, I mean the things that the employees are normally meted out, such as suspension, reprimand, or even up to termination. So, if I'm were to be asked what the board's role is, the board's role, as I see it, is primarily to educate and guide county employees in how to comply with the code of ethics and how to demonstrate ethical behavior.
So that is one of the issues for me, is that at this point, even if we go to a formal hearing, if it should go that far, and we do present to the county council our concerns, the county council has already decided that they're not going to deal with the issue until after the trial, and so it's difficult for me to recommend that we move forward, because I do see the potential of the trial just being more difficult due to the amount of press that's out there. But I'm willing to hear other opinions and discuss this further.
Madam Chair. So,
No.
Mr. Marai, now, if I'm correct, right now we would be at an informal advisory opinion level.
That's correct.
Let's just say hypothetically, we tell the mayor, hey, don't anyone using their P card, that no matter what the circumstances, that's not okay. Okay. Unless the mayor wants a formal advisory hearing, that ends the whole argument. Is that correct?
The county employee may request a formal
Right.
hearing, and of course, by formal hearing, that it's
But it has to be the employee. Is that not correct?
no, I believe the board can.
Well, we cannot fire the mayor. Say one of the testifiers earlier said, "Hey, the mayor could be
Yeah.
fired." The council can't fire the mayor. The only way would be to have a impeachment, or where you get signatures, or recall where you get signatures. I mean, it's not like he can be removed from office via this procedure without recall or.
Well, I'm personally, I'm serving as a special deputy corp counsel to the Board of Ethics, so I don't want to speculate on anything that could happen beyond the scope of this board's powers. I just note that this board does not have the power to discipline.
We don't. Could we fine the mayor, in your opinion?
I'd have to check the rules.
Well, I think, I don't
forget.
know, Mr. Adams wants to chime in.
Our ability to administer any fines at the moment doesn't exist under the current code. because even though the council has given this board the authority to do that in previous ordinance, that ordinance only goes into effect when we change the rules, when the rules are updated. The rules have not been updated since that point. So when the next time the rules are updated, then that ordinance will take effect, and we will then have the authority to issue a fine.
Once we have the informal advisory opinion, and let's say we do one, if the mayor accepts it, do we ever move to a formal hearing?
I don't need to give you a legal interpretation. I can just read from the rules.
Yes.
Is if the person charged fails to comply with such informal advisory opinion within a reasonable time without requesting a formal opinion, or if a majority of the board to which the board is entitled, meaning currently 3, is entitled, determine that there exists probable cause for belief that a violation of the code might have occurred, it may institute proceedings for a formal opinion upon formal hearings. But you have to go through the process of the informal first.
Okay, so we are discussing whether this petition number 2015-3 is going to be continued.
Our position all along was to defer pending the disposition of the Attorney General's investigation. Now, at some point, we debated, what does the term disposition mean? Does that mean now that they're charged, that it's been, that part is over, that's disposition? Or do we have to have a verdict, sentencing? Is that disposition? I took the approach that that was what disposition meant. Mr. Adams had some other concerns that put this back into play. But the bottom line, it's always been our position to have the hearing. I'm in full support of having a hearing. If we find out at the October meeting the trial, we set it for November. I move we set it for November. If it doesn't happen, we go forward anyway. There's still time. But the fundamental constitutional right to a fair and impartial trial by a jury of one peers, we should honor that no matter who it is. And it makes no difference, practically speaking, if we do it in November or now. So let's do it in November.
Board Member Goodnow, did you actually mean to make a motion, or because we have another motion pending?
Well,
I took that as a rhetorical flourish.
Well, maybe I'll move right now. I move we.
Well, we
can't-
have
you
to
can't
finish.
make a motion.
Yeah.
It's not alive.
Yeah,
Okay,
yeah,
thank
we
you.
have to finish with this motion first.
The motion actually
Yes.
is to end the deferral and bring the petition back for consideration. That's the actual motion. So, just so we're clear, a vote to support means to support ending the deferral and allowing this board to then bring the petition back for consideration. A vote opposed means essentially that we're continuing the matter.
Continuing the matter till disposition, which is the trial is over. As soon as the trial is over, it's back on the agenda.
Continuing the matter until we vote to end it. It doesn't matter. Whatever the reasons are, we still have to vote to end the deferral.
Well, I have no objection to voting to end the deferral if we then continue it to November. So I think the motion should be we either do it now or we wait till after the trial. Because I think the motion that passed was disposition, right?
Madam Chair, if I may, there is a motion pending, and I believe it is as Board Member Adams has described. So I believe he's correct that an affirmative vote means that the deferral ends and the matter is now on the table. A negative vote means that the deferral will continue. If it's sounding as if what Member Goodnow wants to do, and I'm not saying he can or he should do it, is it sounds as if he wants to amend the motion. And if that's the case, then procedurally if there's a motion to amend, the motion to amend is heard first before the main motion is voted on.
I agree with that. That's the easiest way to proceed. So then I will move to amend the motion. Well, the motion is to
End the deferral
end the deferral.
and bring the petition back for consideration.
So it's hard to amend that.
If I might, just for
Please.
hypothetical purposes, not saying that I support the amendment, but the amendment would be at the back end of that, to bring it back for consideration in November.
Okay, so I move that the motion be to the amended motion would be to move to bring it back live, but also defer it to November meeting.
We
So
have
it's, the motion is to bring alive and set for November.
do we have a second on that?
I'll second.
Okay, so we have a second. So, vice discussion.
Just so I understand, what we're talking about is ending the deferral now, but bringing the petition back for consideration in November.
Yes.
Is that correct?
Yes.
Initially, when I voted for the deferral, to me it was to find out what the Attorney General, the investigation that was going to be done by the Attorney General, because we just don't have the resources to do a thorough and fair investigation. I don't think this board, has the staff and has the wherewithal to do a fair investigation, and so that's why I voted initially for the deferral, and so. I had initially thought that we were going to get something from the Attorney General, but that's not going to happen. That we know that there was an impeachment, but we don't really know what the specifics of the Attorney General's investigation is.
I believe you meant indictment.
Indictment.
Yeah.
I'm sorry.
Well, I know that we had requested a copy of. Oh, no, I'm sorry. I know that the staff had obtained a certified copy of the indictment, so we have that in our files. But the Attorney General himself has not communicated with the board directly, to my knowledge.
Do we have any further discussion in regards to the amendment? Right, then we'll call for the question in regards to the amendment. All in favor in amending the initial motion and end the deferral, but continue it for consideration until November, say aye.
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 Okay. Any opposed?
No.
So, I'm sorry, I was thinking,
Madam Chair, the vote appears to be 3 in favor of amending the main motion
Uh,
with 1 opposed. So the motion to amend carries.
Yeah.
And the motion that is on the table now, if I may restate, is to end the deferral of petition 2015-3.
discussion in regards, further discussion in regards to that motion.
I do. I just want to be clear that we get a date on the calendar,
Okay.
that something happens. And I realize it's going to be after the trial if we vote in favor of this. Is that going to compromise your trial in any way?
May I ask what the hearing date and the moving forward at that point?
From our ethics board to have our hearing in November, is that going to compromise your trial in October?
No, I don't believe so.
Okay, so you think you will be through with your trial by the end of October so we can have our hearing in November?
Do you know when your November date's going to be? The estimates at this point are probably through the end of October. That's the estimate now.
Mr. Singh, this board normally meets on the second Wednesday of the month, so that would be November 9th.
I believe the trial will be concluded at that point.
By us waiting until then is not going to compromise your trial, your presentation, anything like that? Should not, correct?
I don't believe so, no.
Okay.
I'm not sure as opposed to what, but moving forward now, I mean, it's certainly, in my opinion, the right move to move it to November.
Any further discussion? Go ahead, Mr. Kunal.
Well, I support the motion. And I note that if we had to, we could have another meeting in November. I mean, we could have a special meeting if it was required. Whether because it took that long to get hearing, I mean, I'm committed that we finish it for sure. And I think there's time to do that.
And just for clarification, do I understand that the county council also decided to not take any action until after this trial as well? Is that correct?
That's my belief as well, but
I mean, do we know that for a fact?
I wasn't present, but I've read the news reports where the county council voted 7-1 not to reprimand. Is that what you're referring to?
Or until after the trial? I mean, is that what the county council, what did the county council vote to do?
So I wasn't there, but I've read reports that they voted not to reprimand.
Until after the trial or not to reprimand, period?
I think not to reprimand, period, but I'm not 100% on that part.
Okay. Does anybody else know the answer to that question?
Any further, Manao?
Right, I will oppose the motion. I believe we should get on with this. I don't think that what's happening on the criminal side has anything to do with our ethics side. Thank you.
All right. Then I'll call for the question. All in favor of the motion, the amended motion, yep, to end the deferral and continue for consideration in November, say aye.
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 And then any opposed?
No.
So that motion is carried.
The motion carries.
One procedural question, Madam Chair. So this item, number 2015, will be put on the November agenda, and the petition submitted by Mr. Heinrich as a
Item.
companion will also be put on the agenda at that time? Is the one that we actually rejected, but he sent a signed version, that one.
The instructions to staff by the board were to place it on the next meeting's agenda, which I presume would refers to the August meeting of this board.
So are you going to fly over for that, or?
I don't know. I presume I am.
Okay, thank you for making that clear.
I take it back. I mean, I suppose one of the things the board needs to determine is whether the petition that has been submitted as a companion is really really should be a separate petition. Well, and it also, the board's review may even include matters such as, does it even allege a violation of the code of ethics? It makes allegations, but what the board needs to consider is, does it allege a violation for which this board has jurisdiction over? So I know that if it's the reason why I'm here as special counsel is because the 2015-03 was filed against the mayor. Now, if it's an action as to a board member, I'm not sure whether the the Hawaii County Corporation Council may decide whether her staff can handle can advise a board in a matter against one of its members, or whether they need to involve me or anyone else as a special deputy corporation counsel. So I don't think that that's something that I can answer today. But it's something that perhaps the corporation counsel may request of me for the matter regarding board member Goodnow.
I would note that we had the Corporation Council present. Perhaps we can ask the question. And then if the members feel like this is an executive session discussion, that's also something that we can consider.
Regardless, I'm not sure that this is a conversation we need to have right now. Is all I'm saying is we've already decided to set it for the matter regarding member Goodnow for August. The only thing that's up in the air is whether I personally am going to be here or not.
I just don't know why we're even considering a petition that's not even accompanied by an affidavit from a real person. It's based upon anonymous hearsay. Why are we doing that?
That's never
Because the
been-
rules, I'm sorry.
Go ahead, Counsel.
The rules allow the board to, the things that you speak of are the considerations that the board has when it decides to whether to accept or not. The problem that we have is that all we know is that a signed copy was submitted, but we don't have it in front of us.
That was my discussion
Yeah.
in anger because it just seems like such a waste of time. Anyway,
So we will have to take it up in August when we have that signed copy, and then go from there.
Madam Chair, on the motion that was just passed, could we set a date certain in November when this is going to happen? So that we know, and hopefully Mr. Kinoy will be prepared, Mr. Ching can, fresh off of his trial, be prepared.
Well, I would assume it would be on our regular scheduled November meeting. I don't have a calendar in
9th.
front of me right now.
The second Wednesday in November is the 9th.
No, November 9th.
Yeah, we've been doing Tuesdays, right?
Oh, I'm
Uh,
sorry. The 9th is Wednesday. If it's a Tuesday, then it's the 8th.
November
So
8th.
November 8th.
I would only note that the second Tuesday is Election Day.
Oh, that's right.
And I can tell you the Campaign Spending Commission is not going to meet on the 9th if the day of the election is the 8th.
Chair Kohala?
Ye-
I have a calendar. It is the 9th of November because 8th is the election, so it's on a Wednesday.
Thank you. So do we wanna put that on the calendar then for November 9th? Is that okay, everybody with that? Yep. All right, so.
I'm
so
sorry,
we're-
but that's for the hearing on 1503.
Yes, correct.
Okay.
That's for hearing petition number 2015-03 for November 9th, to put on that agenda. And I think that concludes that petition.
May I ask,
And
excuse me, Madam
Yes,
Chair.
sir.
May I ask a question procedurally with respect to that?
yes,
The reconsideration of the previous deferral seems to have its inception in a request by Mr. Highland. And I just wanted to bring up, if tomorrow he files another one of these requests, are we meeting next month to do this again?
The reconsideration was initiated by the board, right? So the petition, the fact that the petition is on here, now, if he identifies another petition and comes forward with another petition, as he is obviously allowed to do as a person, according to our rules, then of course, you know, if everything is the way it's supposed to be, then I would assume that it would show on the agenda. And then we would take it in, you know, in terms of the matter that it is. But the end of the deferral and the reconsideration was initiated by the board.
Thank you. I just said that because I see a letter in my file that says, please consider this as a reconsideration, a request to reconsider.
And yes, that occurred, but that did not procedurally initiate the reconsideration.
Thank you, sir.
Madam Chair, I don't have anything further to
All right.
add.
okay, then we're moving on. Thank you very much. We're moving on to petition number 2016-05, review of draft informal advisory opinion regarding petition from Clyde Komatsu to determine whether there would be any violation to section 2-83B of the Hawaii County Code if volunteer fire personnel participated in a community service project. Is the petitioner here?